So the next question was asked in 2020. So let's see the questions. It's 2020. Let's see the questions. Now the question says that the Rajya Sabha has equal powers with the Lok Sabha. Now if you remember that the similar type of questions we have already been discussed. So the concept on the basis of basis of comparison of power, comparison of power between Lok Sabha and Rajya Sabha has been asked many times in examinations. And also we know that the Lok Sabha and Rajya Sabha being two houses of parliament. So the parliament. So there are three circumstances where the power of both houses may be unequal. There are certain circumstances under which, so we can say that there are certain circumstances where the power is equal in terms of Lok Sabha and Rajya Sabha. So they may be the related to the amending of the constitution. They may be related to the president, or we can say that it is related to the federal. If there is a question of federal structure, so we can say that the power of Lok Sabha and Rajya Sabha has been equal. But when it comes to the direct responsibility to the people of an legislative, so Lok Sabha has more power. So Lok Sabha is greater, having a greater power than the Rajya Sabha, like passing of no confidence motions related to budget, right? Or we can say that related to the economic control of. So this in these it has been more power given to the Lok Sabha. Now there are third circumstances where the Rajya Sabha has more power or greater power than the Lok Sabha. So there are certain circumstances where the Rajya Sabha has more power, like creation of all India services, right? Then Article 249 is a situations where the Rajya Sabha has more power. Clear? So these is the three circumstances when the power between the Lok Sabha and Rajya Sabha has been equated or compared between these two. Now, if you go to the options given to us in the questions, so the question is asking whether Rajya Sabha has equal power. It means when both Rajya Sabha and Lok Sabha has an equal footing in deciding certain matters. So the first option says the matter of creating new All India services, that is under Article 312. Now the creation of All India services is been given the more power in this section is to Rajya Sabha. So Rajya Sabha has more power than Lok Sabha in the matter of creating All India new All India services. And we all know that there are only three All India services. That is, one is IS, one is Indian Police Service, and one is Indian Forest Services, right? So if the government wants to create or include any new services into All India services, the first it has to be initiated through the Rajya Sabha, then only any new services can be created. So in this, the Rajya Sabha has more power, but we need to answer whether Rajya Sabha and Lok Sabha has equal power. Now, if you move to the next option, that is amending to Constitution, that is under Article 368. Now, amending to Constitution is a something like which is related to the federal systems, federal structure systems, where rigidity of the system or the Constitution has been dealt with. Rigidity of Constitution has been dealt, right? So in this we can say that the Lok Sabha and Raj Sabha has equal power with respect to Article 368. So answer to this question is B, that is amending of the constitutions. If we see the third options, why the third option has no Rajya Sabha has no power. So if we see that the removal of government, now we know that the government of the India or the government of the union, or we are talking about the states, so they are responsible to lower house, that is Lok Sabha. So only the Lok Sabha has the power to remove, right? And we also know that the council of ministers can only be in office till they enjoy the confidence of the house or majority of the house. So the government is formed on the basis of majority in the Lok Sabha. So government in India at the union level is not been formed on the majority of the parliament. Rather, it has been the government who wants to form a government. The party has to come up with the majority in the majority in Lok Sabha. So the being majority, they have to prove in the majority of Lok Sabha. So if the majority has not been proved in Lok Sabha, so it means the Lok Sabha will remove the government. So in this case, the Lok Sabha has more power than Rajya Sabha, right? Now the next is moving cut motion. Now this cut motion is used in the form, this cut motion is a three types of cut motions. If you see that, the first is policy cut, the second is economic cut, and the third is token cut. So this cut motion is used to disapprove the budget of the government. Now it means it is again controlling, sanctioning the government. So the control of a government is been, and this amounts to the financial control. This amounts to the financial control of the government. So the government is always been controlled by the Lok Sabha. So in the cut motion also, the Lok Sabha has more power. So out of the options what we have been provided related to this questions is that amending of the constitution is a subject where both the houses have equal power. Is it clear? Okay. Now let's see the explanations to this. So in this, I have tried to make the list with the positions of Rajya Sabha with the respect of Lok Sabha. So there is three positions where the Rajya Sabha has equal status. Rajya Sabha has equal status with the Lok Sabha. It means the Rajya Sabha and Lok Sabha power are equal. The second circumstances where the Rajya Sabha has more power than the Lok Sabha, and the third circumstances where Rajya Sabha has less power than Lok Sabha. So now we see that those circumstances where Rajya Sabha and Lok Sabha has equal power. So the first, in the introduction and passage of ordinary bill, both the houses have equal power. Introduction and passage of CAB, that is a constitutional amendment bill. So in this also both have a similar power. Introduction and passage of finance bill, second, that we have seen in the uh, last questions according to article 1703, they have the both equal power. Election and impeachment of president, both have an equal power. Election and removal of vice president, again they have an equal power. Making recommendations to the president for removal of chief justice of India and judges of high court and Supreme Court and High Court, including the chief justice of high courts also. So both have an equal power. Approval of proclamation of all three types of emergencies by the president is also having an equal power. Selection of ministers including prime minister, so yes, the prime minister can be selected from Rajya Sabha or from the Lok Sabha also, and ministers can also be from either house of parliament. So the constitution does not restrict that the president prime minister should only from the Lok Sabha, but it says it should be a member of house, so it means it can be from Lok Sabha or Rajya Sabha also. Then considering the reports of constitutional bodies like finance commissions, like CAG, UPSC reports, or committees on scheduled caste and scheduled tribes, all those constitutional bodies, so both have an equal power in considering those reports. And the last is enlargement the jurisdiction of Supreme Court and UPSC. So these all factors somehow somewhere shows that whether Lok Sabha and Rajya Sabha has an equal power. Is it clear? Now let's see the second circumstances where the Rajya Sabha has more power with respect to the Lok Sabha. Now there is only two circumstances where Rajya Sabha has given more power than the Lok Sabha. The first is Article 249, which authorizes the Parliament to make a law on subject enumerated in the state list. So this article, through Article 249, the Parliament is empowered to make laws on the state list. So if the Parliament want to make any laws in the state list, so first that has to be passed through the Rajya Sabha, then with a special majority, then only it authorize the Parliament to make laws on state list. So this what has been matter. This is what has a special power. The next special power of the Rajya Sabha is Article 312, that is creation of All India services. So this is the first statement option, that creating a new India also new All India services, where the Rajya Sabha has not an equal power, rather has an more power than Lok Sabha. Now if you see the third and the last comparison, that is unequal status with Lok Sabha, where the Rajya Sabha has less power or the Lok Sabha has more power, or a matter where Lok Sabha is been sole responsible, right? So the first, all matters related to money bill, that comes in the sole responsibility of Lok Sabha. Speaker presides over a joint sitting of both the houses. This is also uh, having where the Lok Sabha is more power than the Raj Sabha. Then Raj Sabha can only discuss budget but cannot vote yes during the budget. There out of the 6 stages in the budget, there is a 6 stages in budget, and the Raj Sabha has power only for the first and the second stage, that is of the introduction and general discussion on budget. Beyond this second stage, the Raj Sabha has no power. It means it cannot vote on the budget, which means that it cannot use the cut motion, which is our the fourth options. So this also we can show that where the Lok Sabha has more power, right? Then next, D, a resolution for discontinuation of national emergency can be passed only by Lok Sabha. This is also true related to Article 352. We have also discussed in the previous questions where it has been asked. So the disapproval of a national emergency, we are talking about Article 352. Not we are talking about the president or financial emergency, but disapproval of national emergency is only where the Lok Sabha can disapprove it. And the next is no, and the last is no confidence motions against the government can only be introduced in the Lok Sabha and can be passed by the Lok Sabha. So Rajya Sabha has no business related to the no confidence motions. Is it clear? This the questions has been asked from the comparisons, and this we can see that this is a repeated concept. This question has also been asked previously. Clear? So moving to next question. Now next question was asked in 2019. So next question was asked in 2019. Now before discussing these questions, this is a such type of questions where this is an purely a factual questions, where you should be knowing every detailed fact of the option, then only you can make an correct answer, or where this also on the basis of your knowledge you can use an elimination method. So let's try to see that on in this type of factual questions how we can use an elimination method, and is the elimination method works on this or not, right? So there are three statements and we need to find a correct statement, right? The first statement, the Parliament Prevention of Disqualification Act 1959 exempt several posts from disqualifications on the grounds of office of profit. So first of all, we should know that there are such type of act which talks about an office of profit. Second, that it has a certain exemptions. If you know, then it's good. If you do not know, there is no need to panic. Let's move to the next statement. So here one thing you need to understand, that whenever you find such type of statement or questions where you are not been confident or you have no idea about the question, so don't be panic, just move to the next questions and try to use the elimination method and try to find whether the next statement can be answered or not. So let's assume that we have no idea about this statement. Then moves to the next. The above mentioned act was amended 5 times. Now this is again an absurd statement. Now how we can, it has been expected from that we should know that which act is amended how many times. So this is also, let's consider this is also not we have been in place to remember or been knowing in this order, right? So let's suppose that the first two statement we have no idea whatsoever that whether it is right or wrong. So let's move to the third statement. Now assume that there are only two statements in the given question. So if you are even in positions to eliminate by your logical knowledge based logic, then it's okay. If not, then My advice is to you, will be to you, that leave these questions and move for the further questions. But it has all, but in this questions it has a third statement. So let's see whether the third statement can help us to answer this question or not. So the term office of profit is well defined in the Constitution of India. Now this we can say on our knowledge based logic, that the office of profit has been mentioned in it, mentioned in Constitution of India, but not defined, and he had said well defined. So the Constitution of India has not defined the term office of profit. It has just mentioned at the place of qualifications of president, at the place of qualifications of vice president, but it does not define. So the third statement is incorrect statement. Now, out of the three statement, we are in a position that are very confident that third is incorrect. So through the statement 3, let's eliminate those options that contain third statement. So B cannot be answer, C cannot be answer, and D cannot be answer, right? So we are left with only 1 and 2. So here we can say that without knowing or without having no idea whatsoever about the first or second statements, on the basis of the third statement, which we are very confident and we know that this is incorrect, we can mark our answer, that is 1 and 2. So this is how you can use this technique in your examination also in every subject. So, but that has to be not be blindly use an elimination method. But to use an elimination method, it is necessary that you should have a background, a knowledge background related to the topic, and that can be used as a reasoning in these questions. Clear? So with respect to the this office of profit, this has not been defined in the constitutions, not defined in the constitutions, right? But the Supreme Court has said that those offices comes under office of profit, which provide pecuniary monetary benefit. Monetary benefit. So if any member is drawing up, or if any office is taking care of anyone's pecuniary monetary benefit, so that kind of office will be considered as an office of profit. Now pecuniary monetary benefit means, suppose that a person is been elected as a president, right? And it is said that the president shall not be hold any office of profit either under the government of India or under the state government, right? But a president is a member of any committee. It is a member of a committee, right? So being a member of this committee, whenever the committee called its member for a meeting, they've sent a flight ticket. It means this committee is been taking care of his traveling charges. That is providing a pecuniary monetary benefit, or you can say that they provide them a chauffeur with the car. It means again they have been taking care of certain pecuniary small monetary benefit provided. So any of these type of pecuniary benefit will be considered that the president is holding the office of profit if he has been associated with anyone. But if a president is associated with any committee and the committee is providing nothing to him, it means he has been taken it has not been provided any kind of peculiar benefit, and even though he is a member of that, that will not be considered as an office of profit. Is it clear? Hope this would have cleared your concept related to office of profit. Okay. Now let's see the explanations to this office, this questions related to the first two statement. The Parliament Prevention of Disqualification Act 1959 was enacted to exempt certain offices from being considered as an office of profit, thus preventing disqualifications of MPs and MLAs who hold these posts. This act specifies the list of offices that do not attract disqualification under Article 102, Clause 1, Subclause A, and Article 191, Clause 1, Subclause A of the Constitution. This is related to the member of Parliament disqualifications, and this is related to member of State Legislature disqualification. So yes, the first statement is true. because it has certain, the act has certain several posts that been exempted from this, right? Now the act has been amended five times in 1916, 1992, 1993, 2006 and in 2013. These amendments updated the list of offices that are exempt from disqualifications to reflect changing administrative and political requirements. So yes, the second is also true statement. Now the third says the constitution does not define the office of profit, the term office of profit. The interpretations of what constitute an office of profit is based on judicial pronouncement, parliamentary debate and precedents. Court have laid down certain principles to determine whether an office is an office of profit, such as whether the office carries financial gain, administrative control or benefit from the government. So these are the certain principles on the basis of which the office of profit can be determined. But this office of profit is not been defined in constitutions, nor the Supreme Court has also defined. So not the Supreme Court has also defined the term office of profit means what. Is it clear? Okay. Now let's move to the next question. So next question was asked in 2019. So let's see the questions. Now with reference to the with reference with reference to the Legislative Assembly of State in India, consider the following statement, right? So the first, governor make a customary address to members of house at the commencement of the first session of the year. Yes, this is true, and this is similar to that of a address of the parliament by president. So president addresses the house of parliament, right? But here the governor is been asked, so we can understand through this that the governor has power to address the assembly, and if any state has a council, so the assembly and council in the on the two occasions. The first sitting of every financial year will be addressed by the governor in a joint sitting if the state having a legislative assembly and legislative council, and if only a assembly, so the assembly will be addressed. And the second occasion when the governor addresses the very first sitting of newly elected house. So this is the two occasion on which the governor is addressing the house, state legislative assembly. And if there is a council in certain states, so both were to be addressed in a joint sitting. So accordingly, the first statement is true. So this is a true statement. Clear? Now when we move to the next, that when a state legislature does not have a rule on a particular matter, it follows the Lok Sabha rule on that matter. Yes, logically it is true, because the state legislature is similarly, not identical, but similarly functioning on the line of Lok Sabha. So whatever the rule the Lok Sabha follows, it is almost similar that they follow the rule. And if they do not have any such rule related to the functioning of the house, so they can borrow from, or they can take inspiration from the Lok Sabha's rule. So both of this statement is correct. So we need to find the given statement are correct. So answer to this question is C, that is both 1 and 2 is a correct statement. Clear? Now if you see the explanations to this question, so let's see the explanations to this question. So the first, article 176, according to article 176, a special address by the governor. So a special address by governor, the governor is required to address the state legislature at the commencement of there is two occasions. So first, the first session after a general election of legislative assembly, and the first session of each year, that is at the starting of financial year. So this is the two occasion when the governor address the house. Now what do you can say that house or address of a message in the governor. So the governor's address outlines the policies and programs of the state government for the upcoming years. It serves as an agenda setting exercise, highlighting the government's priorities and legislative plans. And if you remember, if you know that there is one term which is known as a motion of thanks. So this motion of thanks is a motion passed by the House if it has a unicameral, then only the House of Assembly, or having a bicameral, then Council also. This motion of thanks is passed is a token of thanks towards the governor address towards the after the governor address the houses. So the House shows gratitude towards the governor by passing motion of thanks. If the motion of thanks is not been passed in the House, so it would be considered that the government has fallen. So government lost its majority in the House. So the government has to resign. So it is necessary and it is mandatory that the motion of thanks should be passed by the House. The failure of motion of thanks considered as a failure of government or loss of government. Clear? Now, discussion on address. So, address is followed by motion of thanks, where members of legislature discuss the content of the governor's address. The discussions provide an opportunity for legislator to debate and critique the government's policies. And if the motion of thanks has been passed, so the government having a majority in the House, and if the motion of thanks has not been passed, so it would be assumed that governor lost his majority and the government has to resign. Clear? So this is Article 176 about the address of governor. Now for the second statement that says in the Article 208 deals with the rules of procedure in state legislature, which says that a house of legislature of a state may make rules for regulating subject to the provision of this constitutions, its procedure and conduct of business. Until rules are made under clause 1, the rules of procedure and standing order in force immediately before the commencement of this constitutions with respect to the legislature for corresponding province shall have an effect in relation to legislature of state subject to such modification and adoptions as may be made therein by speaker of assembly or chairman of council as the case may be. Therefore, when there is no rule on particular subject in state legislature under a convention since colonial times, the state legislature follow the rules of Lok Sabha. So this is a convention, though it has not been a constitutional provisions. So we can say that the second statement accordingly is true. Clear? Moves to the next question. So the next question was asked in 2018, and this is again repeated. Not a question has been repeated, but the concept which is money bill has been repeated. And we have seen the definition of money bill is given under Article 110, and the procedure related to money bill given under Article 109. So 109 is also been asked, and now there is a question on 110 which has been asked in 2018. So let's see this. Regarding the money bill, which of the following statement is not correct? Now here we need to find the statement which is not correct. So if we see according to Article 110, that is a definition of money bill which says that that bill will be called a money bill if it contains only either all the items, all or any of the items under Article 110, then that bill will be considered as a money bill, right? So the bill should not be contained any other provisions other than Article 110. So a bill, if it is a bill talking about any one of the provisions of Article 110, then also it will be a money bill. If it contains more than 1, 2, 3 or all the provisions, then also it can be considered as a money bill. So this is a conceptual related to Article 110 which talks about a money bill. Now sees the given 4 options. The first says a bill shall be deemed to be a money bill if it contains only provisions related to imposition, abolition, remission, alterations or regulation of any tax. Yes, it is true. Now this is a very factual question, so to answer this questions you have to remember the Article 110. What are the provisions or definitions of money bill that has to be remembered? This is true that clause A, the first conditions, subclause A of the Article 110 talks about that impositions, abolition, remission, alteration or regulation of any taxes. So accordingly to the definition of Article 110, a bill will called be a money bill if and only if it contains only the provisions, either all of the provisions or any of the provisions of Article 110. So this, the first statement says that it contains the first provision. So yes, it is a money bill. So first is true. So this cannot be our answer. Then moving to the next. A money bill has a provisions for the custody of consolidated fund of India or the contingency fund of India. Yes, it is also true, right? So according to subclause C of the Article 110. Now, being I will be very frank to you, to answer this questions. You had to be very factual with the Article 110. If you have remembered or if you have been very keen to this, then only you can answer this question. So this is also, the second statement is also true. Now the third says a money bill is concerned with the appropriation of money out of the contingency fund of India. Now this is where we need to apply certain logic behind to eliminate this method. Now what it's talking about, it says that a money bill is concerned with the appropriation of money out of the contingency fund of India. And on the basis of our knowledge background, we know that this contingency fund of India is a fund, is a such type of fund which has been used in an emergency, right? And then due to this provision, it is under the disposal of executive. Under the disposal of executive, it means it is a president who give the advance out of contingency fund without having a permission from parliament. So there is not, so parliament has there is nothing to do with the permission of getting a permission from parliament to withdraw money from contingency fund of India, because this fund is been created to use in emergency at the disposal of executive, that is president. So, and the money bill, as we know, this is related to public purse. Yes or no, right? So on that basis of logic, we can say that it is not an appropriations of contingency fund, but it is an appropriation of consolidated fund of India. And this consolidated fund of India is considered morely to the public purse, where all the incomes of the government comes under the consolidated fund. And this consolidated fund, according to Article 266, is at the disposal of legislature. That is, the parliament can authorize the withdrawal of money from consolidated fund of India, but the withdrawal of contingency fund of India is at the disposal of executive. So on this logic, we can say that the C, that statement C is incorrect, because the money bill is more concerned with the public purse, though it is also a public purse, the money of the public in this fund, but this is mainly under the hand of executive. Clear? So C is been maybe the answer to this questions. Now if you see the third last of the given options, a money bill deals with the regulation of borrowing of money or giving of any guarantee by the government of India. Yes, it is true. So this has been dealt under subclause E of the Article 110. So we can say that D is been also true, but C is not true statement. Clear? Now if you see the explanations to this, and when I say the explanation, it means we need to see the Article 110, the definition of money bill. So Article 110 is a definition of money bill. So clause 1 says, for the purpose of this chapter, a bill shall be deemed to be a money bill if it contains only provisions dealing with all or any of the following matters. So the first says that impositions, abolitions, remissions, alterations and regulation of any tax. That is the first statement. So on the basis of this, true. Second says, B said a regulation of borrowing of money or giving of any guarantee by the government of India, that is D. Or amendment of the law with respect to any financial obligations undertaken or be undertaken by the government of India. B. C said the custody of consolidated fund or contingency fund of India, the payment of money into the into or withdrawal of money from this such funds has been also been dealt. So the B is also true. D says the appropriation of money out of the consolidated fund of India. So the D has been modified and made the appropriation of contingency fund of India. But it is not true. Why? Because contingency fund of India is at the disposal of president. So it is the answer. Now if you see the next E, the declaration of any expenditure to be expenditure charged on consolidated fund of India or the increasing of amount any such expenditure. F says the receipt of money on account of consolidated fund of India or the public account of India or the custody or issue of such money or the audit of accounts of the union or a state, or the G, the last one, any matter incidental to any of the matters specified in subclause A to F. So this is an if any of this matter contains, so this will be called as a money bill. Clause 2 of Article 110 says that a bill shall not be deemed to be a money bill by reason only that it provides for the imposition of fines or other pecuniary penalties or for the deemed demand or payment of fees for license or fees for service rendered or by reason that it provides for the imposition of abolitions, remissions, alterations and regulation of any tax by any local authority or body, right, for the local purpose. So if the any bill is demanding to imposition of fines, so it is not a money bill. Demanding imposition of penalties or fees, so it is not a money bill. Fees for license or services, it is not a money bill. And also if the bill is trying to impose or abolitions or remissions on taxes by local authority, then also it is not a money bill. Now clause 3 says if any question arises whether a bill is a money bill or not, the decision of the speaker of the House of People there shall be final. So that cannot be challenged. Clear? The clause 4, there shall be an endorsed on every money bill when it is transmitted to the Council of States under Article 109 and when it is presented to the President assent under the Article 111, the certificate of Speaker of the House of People signed by him and it is its money bill. It says that if a money bill has been passed by Lok Sabha and transmitted to the Raj Sabha, so after the bill has been passed by Lok Sabha, it has to be certified by the Speaker that it is a money bill. It is a money bill. And this certifications also bear in the bill when it is presented to the President under Article 111 for his assent. So certification of the Speaker is an authentication that bill is a money bill, and that authentications and the certification is final. Is that clear? Okay. Let's move to the next question. So the next question was asked in 2018. Now let's see the questions. So the Speaker of a legislative. So consider the following statement. So there is two statement, and this is again related to the Speaker. That is a presiding officer of State Legislative Assembly. So the Speaker of a Legislative Assembly shall vacate his or her office if he or she cease to be a member of Assembly. Yes, it is true. Why it is true? Because the Speaker is a, who is the Speaker? So Speaker is a member, so member of the Assembly, right? So when the government forms, they choose a members among the Assembly, among the member Assembly, and then he's been elected as Speaker. So it means that a Speaker has to be a member of Assembly. So if any member resign from his seat or his membership, so he will also lose to be a Speaker of the House. So this is true. Now if you see the second statement, whenever the Legislative Assembly is dissolved, the Speaker shall vacate his or office immediately. No, this is incorrect, and this we have already been discussed when we have discussed the previous concept related to Speaker. So when the Speaker in the House, a Speaker is the last one to resign from the House. So when he resigned just before the sitting of newly elected House, right? And just before, evening just before. So we can say that one day before or evening just before the newly elected house is commenced to sitting from the next day. Suppose that house is dissolved, and from next day, the election, after elections, the counting and the everything has been decided. So the house is going to start from the next day. So in today's evening with the last day of the speaker. So speaker will resign from his office just before the evening of the first sitting of newly elected house. So he's not resigning from his office or vacant his office after dissolutions. It is the last one. So speaker is the last one to resign, right? So this is the second is incorrect statement. So our answer to this question is A. That is only one is true, correct, right? Now let's see the explanation to these questions. So, according to Article 178 and related provisions in the constitutions, the Speaker of Legislative Assembly must be member of the House. Yes, it is true. Similarly to the Speaker of Lok Sabha also. If the Speaker ceases to be a member, that is due to resignations, disqualifications, or losing an election, they must vacate their office immediately. Yes, are you getting my point? Yes or no? Clear? ठीक है. Now next, moving to the next. Article 179. Vacation and resignation of and removal from the office of Speaker and Deputy Speaker. So a member holding office of a Speaker or Deputy Speaker of an Assembly first shall vacate his office if he ceases to be a member of Assembly. Second, may be at any time by writing under his hand address if such member is the Speaker to the Deputy Speaker, and if such member is Deputy Speaker to the Speaker resign his office. It means that they can resign from his office. So Speaker will address his resignations to Deputy Speaker, and Deputy Speaker will address his resignation to Speaker of the House. Clear? Next, they can may be removed from his office by resolutions of assembly passed by majority of all the then members of assembly. Yes, provided that no resolution for the purpose of clause C shall be moved unless at least 14 days notice has been given to the intentions of resolutions movement. This we have seen when we have seen a questions related to Speaker of Lok Sabha that was asked in 2024. Now, provided further that whenever the assembly is dissolved, the speaker shall be not vacant his office until immediately before the first meeting of assembly after the dissolutions. That is after elections, when the newly constituted assembly meet. So before just first meeting, the deputy speaker will or a speaker will resign from his office. Is it clear?